So you sign up the client, you are now fully performing the services when you receive a phone call. Yes, that is your ringtone. And the client says, I don't want XYZ, I want ABC. You say, okay, that sounds great. Is that binding? Are either of the parties required to adhere to that conversation and the obligations stemming from that conversation? Find out in today's video. Hey out there, welcome back to Wedding Industry Law. My name is Rob Schenk. I am a wedding industry attorney, and in today's episode, we're talking about whether or not any type of verbal agreement or verbal amendment or change to a contract is binding. Is that something that is possible? Before we get into it, though, I do have a request, and that is if you have a question about running your wedding business, if you want to talk shop, legal shop, so to speak, then please join me over on Clubhouse every Thursday at 4 p.m. Eastern, 1 p.m. Pacific. I moderate and host Wedding Industry Law Hour, where I, for an hour or so, answer questions about running a wedding business, the legal aspect of it. So if you've got questions, to the greatest extent possible, I will answer them as best I can in that forum. I can't give specific legal advice for specific situations, but it's a good time. We got a lot of interesting questions answered, a lot of good conversations started. In fact, some of the episodes that we've been having over the past month or so has been because of the conversations that we started over at Clubhouse. So I encourage you to find us over there. I'm at Wedding Lawyer on Clubhouse. Again, every Thursday, the Wedding Industry Law Hour, 4 p.m. Eastern, 1 p.m. Pacific. Okay, now, the question here is a verbal agreement, meaning an agreement being that both sides are okay with the change to the contract. If that's done in a conversation, is that binding? And typically, almost in every jurisdiction, the answer is yes. If it meets the other criteria of a contract, meaning there is some type of exchange of consideration, then absolutely a verbal amendment to a contract can be binding. Okay, so just because it was a telephone call doesn't mean that it's not something that you have to do. Okay, so in other words, don't say, well, I might have said I would do it on the phone, but it's not in writing. That is typically not going to be a defense for you. It's typically not going to be a defense for the individual that, or your client or the couple. Now, just because it's verbal, and it likely could be, if it meets the criteria of a contract, binding, doesn't mean that you should not, in almost all instances, follow up with some type of written, what we would call memorialization, some type of document that reflects the conversation that you had. So if it's over a telephone call, if it's like, okay, well, you want XYZ, that's fine, but you're going to pay me more or less, or whatever the consideration is, whatever that understanding is that you've had on the phone, you want to put that in some type of writing, and that can be in an email, for example. So you would say something along the lines of, hey, client, fantastic talking to you today. In our conversation, I just wanted to follow up that we agreed X, Y, and Z for 1, 2, 3. If I got that right, please let me know in the affirmative. If not, let me know what we got wrong. And you are essentially wanting the client to have a follow-up email that says, yeah, that sounds great. XYZ for 1, 2, 3 sounds good. So that way you have a mutual, meaning two-sided, not just you emailing that person with no response, but it's an email that here's what we talked about, and the other side saying, yep, that's exactly what we talked about. So that way you have a written account of that amendment. Not, again, a verbal amendment can be binding. The problem is that typically no one's going to remember anything. I can't even remember what happened on Game of Thrones over 10 seasons, right? Over 10 years ago, whenever that show came out. I can't remember what I had for breakfast. That'd be a better example. I don't know. Was it Crunch Berries? Was it All Berry Crunch? Was it Peanut Butter Crunch? No idea. I can't remember that. So having some type of documentation that flows from both sides that memorializes what you talked about is going to be the best situation for you. Well, Rob, I mean, is that good? Is that better than having the client sign a whole all new contract? Possibly, that having a whole new contract might be better, but you're talking about a spectrum. So on one end of the spectrum, you have an entirely new contract drawn up. The client's there, notarized, their grandmama's there to attest that they are agreeing to everything, and everybody signs in front of a magistrate. On the other end of the spectrum, you have only the conversation. So you could imagine that spectrum that on one end, the conversation end, it's going to be difficult to prove what the terms were that you agreed to. On the other end, with all the memorialization, it's going to be very difficult not to understand what the obligations were of the parties and what they agreed to. So having an email communication back and forth or a text back and forth is going to be somewhere in the middle, right? But it's going to be much easier down the road to explain to a judge, here are the texts between us that shows that we agreed to or not agreed to something. It's just a better policy, a better procedure than relying on a conversation that is in your cabeza. So at the end of the day, conversation, okay, put it in writing, and it's going to be the safest. Now, one other thing before we wrap up this video, and that is you might have a contract that will say something along the lines of this contract can only be amended by mutual written consent, okay? And so you're saying, well, Rob, my contract has that, so there's no way that my verbal conversation with this person can be binding. Just understand this, that in many jurisdictions, just because you have that written into your contract doesn't mean the contract can be amended in any other way, whether it be for performance, behavior of the parties, or a conversation. So just keep that in mind. Okay, so if you're relying on that line in your contract, in many jurisdictions, it's garbage. I'm not saying it's garbage in your situation, but the safest thing to do always is to get a memorialization, some type of back and forth writing, or if you can get the client to sign a whole new contract, that's okay too, but better than a conversation. So long story short, yes, verbal changes to a contract can be binding if there is consideration, if there are an agreement of terms between the two parties, absolutely. The issue will be, what did you agree to? And as your memory fades, what you agreed to could be different. Your perspective of what you agreed to might be different than the other person. So short episode this week, or short video this week, I should say. I'm trying to brand this as videos, and I keep saying episodes. That doesn't make any sense. Videos. Hopefully you found this video to be informative. Maybe you learned something that you didn't know. If you did, please be sure to like the video, leave a comment if you are so inclined, hit the notification bell, or if you're consuming this on a podcast application, leave a review, I guess. I don't know. I tried to review a podcast the other day, and it was absolutely impossible. I could not figure out how to do it. But if you know how to do it, please review this podcast. I would greatly appreciate it. But most of all, go to YouTube and check us out at Wedding Industry Law. New episodes. I said it. See, there it is again. There it is again. New videos every Monday. And with that, folks, we'll see you next week.